5118. All right, we're on record for the initial disposition as it relates to the father of the child. May I have the names of our participants, please?
Carson Howitt, lawyer, guardian ad litem.
Ms. Taja Thomas, counsel for the department. Present in the courtroom is the foster care caseworker, Ms. De La Garza, and then online we have for mom's portion via Zoom, we have the CPS investigator at Chelsea Pelham. Ms. De La Garza, can you please state your name for the record?
Brandy De La Garza, the foster care worker.
Ms. Pelham, can you please state your name for the record?
Chelsea Pelham, CPS.
Michael McFarland, representing father. Please introduce yourself, sir.
John Hilton, father. Thank you.
Any opening comments from our attorneys before we begin with the disposition?
I tried to type, you can't hear him.
Your Honor.
Oh, Mr. Price.
Can I put my appearance on the record? Sorry.
Sure.
Alexis staying on behalf of the minor child.
Your Honor, Michael Brooks, I thought I was representing Mr. Helton. Maybe I've got it wrong, and maybe it's the mother, Ms. Riley. I don't know.
Yes, I have you down as representing the mother in the case.
All right.
I was just looking through our orders for purposes of what's been said as it relates to your client today. I think maybe she's pulling off our radar a little bit. Ms. Thomas.
Yeah, yes, and I would like to apologize to the court again. At the last hearing we had set for pretrial for mom, I had not asked the court for a motion, not motioned the court for an order for alternate service on mom. The department had provided me with essentially they paid for like a background check for mom to try to find the last known address. And then I finally last night had filed that with the court as a proposed order for alternate service. I figured at this point it would be most prudent to wait until we had a trial date, so that way I could submit the order for publication with an actual date for mom to try to appear. I believe that the last known address is in Dallas, Texas, and so we would just ask the court for publication there. Of course, if Your Honor believes that some of the attempts that are listed in the motion would be more fruitful, like sending via messenger on Facebook or whatever, I would be happy to oblige for that as well. But we would just ask for a trial date for mom at this time.
Good, that sounds appropriate. Your position on that, Mr. Brooks?
Well, I'm impressed with the great number of spots that they've looked. I have no objection to making the attempt in any event.
Good. Yes, this is an absent parent. She's been absent. She was documented as absent at the beginning of the case. Mr. Helton testified to that as well. I don't think there's any question that she's not been part of the life of this child for a significant period of time. And I do find it appropriate to set the trial date on her case and to allow the motion for alternative service to be granted and to publish in Texas, as well as to make those efforts by social media as suggested by Ms. Thomas as part of the reasonableness. So a lot of those have been done. So just a new short round of those, Ms. Pelham, with our date after we choose it. And I think that we'll be in good shape to have been doing our best to find and notify this parent about what's happening. So let me get you a date. Mr. Howard, is that acceptable to you?
Yes, Your Honor.
Mr.
No position, not my client.
Thank you. Just checking. All right. So our next review hearing for Mr. Helton will be in approximately 3 months. So why don't we go ahead and set the trial for the same time as our next review. We may have to go slightly short of that 3-month time frame, considering the spring break season. So I have Tuesday, March 24th at 11 a.m., if that works for everyone.
Time again?
11 a.m. on Tuesday, March 24th.
That's fine.
That works for me as well. How long are we setting that for?
An hour.
Okay, thank you.
It's a review and the trial.
Review for your client, yep, review permanency
Sure.
planning hearing, and then it would be the trial for mother. Okay. All right, anything else as it relates to your client, Mr. McFarland?
Yes, Your Honor. I did want to check with the court. My client, after the court did adjudicate him last time, he did file an appeal. I wanted to see if the Court of Appeals issued a stay of proceedings or not.
I did not receive a copy of anything indicating that an automatic stay had been implemented or that a motion for stay had been filed. So to my knowledge, I do have the claim of appeal in front of me. It looks like it's been reviewed by our court reporter and it's ready to be signed and sent up. But as of today, there is no stay that would prohibit us from moving forward or alter any prior court orders.
Thank you. We do not have a signed case service plan. My client indicates to me that he never received it, but he is prepared to sign that today, is what he told me. He just wanted to let the court know that he was never presented with that. And there is some update regarding his drug rehab, his housing and employment that we will have testimony on. Thank you.
Great, I look forward to that. And then any additional response to that from our caseworker on those efforts to engage with Mr. Helton. All right, any other preliminary comments from our attorneys before we go to Mr. Howitt for his report?
Your Honor, I don't know the best way to kind of go about this, but I'm concerned about a claim of appeal prior to initial disposition. It's my understanding the court ruled the claim of an appeal by right is only applicable after the initial disposition. And I did not get notice of that.
It's not really the adjudication, it's the preliminary hearing order removing the child from the parent's custody.
Okay, thank you.
So that's what's being appealed. Just to clarify, that's a good question. So it's not the adjudication, because he can't appeal that, but he can appeal the removal.
Thank you. That's what I mean.
And that's what the claim indicates. I'm looking at it right now. He's asking for an appeal of the order removing the child. And he did file that. So he's appealing the order entered December 19th, which I think was.
Removal.
I think the removal was before that, actually. Yeah, the removal was back in November. That is a good point, Ms. Thomas. Thank you for bringing that to my attention. So the preliminary hearing and the removal order entered November 13th, 2025. And this appeal was received December 29th. So that is more than 21 days after the removal. So that's not a timely appeal. So your client would be able to file a request to ask the Court of Appeals to look at that by leave, but not by claim. If he wishes to appeal today's initial disposition order, he's welcome to do that.
Okay.
Ms. Thomas is correct, and the claim of appeal is actually inaccurate because the order removing the child from the parent's care and custody was back in November. So we'll leave that to you to straighten out with your client after today's hearing in our clerk's office. And is there anything else, Ms. Thomas? Good catch.
No, Your Honor, thank you.
Ms. Stang, any other preliminaries?
No, thank you.
Mr. Brooks, are you gonna stay with us for the rest of today's initial disposition or rejoin us for the trial of your client in March?
I'll stick around and see what's going on.
Okay, very good. Mr. Howitt, let's go to you for your report.
Yes, Your Honor, I was able to meet with the child on January 8th, 2026. He was home from school that day because I think there was some fog last week. But he's doing really well. He's a pretty impressive kid, and I've heard such great things about him, like being a great soccer player. He has tons of friends and a great social life, and does really well in school. And just from meeting with him a couple of times, I can tell that this is most from my perspective, true. And we spent our visit mostly just talking about some things, getting to know each other, but he obviously had some questions about his family and what's going on with his dad. He still maintains that he would like his dad to take care of him, cook for him, be the primary caregiver in his life. And I think they do have a pretty close relationship. But, from reading some of the visit notes and observing a visit myself, I do think that, some of their communication and style is probably inappropriate. And I know a referral was made to do therapeutic visitation, and Mr. Halton had an intake for that on last Friday, but it did not come to fruition. But I still think that's probably the best mode of visitation for this family moving forward. I talked with the child about what this may look like, and he seemed to kind of understand it, but in reality, the workers at Fostering Solutions do a really good job of trying to redirect the conversation and mode it. So I do think that it's okay right now, but I think the therapeutic could be better to kind of help them understand some appropriate boundaries and have more productive visitation. But overall, I think it's in his best interest to remain where he's at and do the therapeutic visitation. He's been in this placement, for the last many years. He's taken care of there, and he has that stability and continuity with this caregiver. So I wouldn't think disrupting that in any way would be appropriate. But he still wishes to be with his dad, and he is understanding that his dad is currently homeless and not working, but he still wishes his dad could be his caretaker. Thank you.
Thank you. Are you suggesting the therapeutic visits be incorporated with the supervised period of time, or that visitation be limited to therapeutic visits only?
I think if we can accomplish therapeutic visits at a weekly basis, then they should be only therapeutic. But if they don't have the availability for that, I do think it'd be appropriate to supplement some with some supervised visits, because I do think the frequency is important.
Okay, thank you for clarifying. Your first witness, Ms. Thomas.
Thank you, Honor. I would ask Ms. Delagarza to be sworn in.
Ms. De La Garza, come on up to our witness stand.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do. Proceed at will.
Ms. Delagarza, as relates to your court report for initial disposition, are there any updates or modifications that you're aware of that need to be made to it on the record?
No.
Okay. And since you've submitted this court packet, have there been any additional documents that you've circulated or received that you would like the court to consider for today's hearing?
I did receive the recommendations from Catholic Charities, but I have not circulated those, but I do have a physical copy here.
Okay. And can you summarize what those recommendations are?
Yes, the recommendations were that he be entered into an intensive inpatient rehab center, which I know that they were working on, and he's just waiting for a bed to open up for that.
Do you happen to know the facility or the treatment center that they are waiting for, or is it just any center that becomes available that they would try to use for Mr. Houghton?
I believe it's any that become available, but the main one that they're looking at is Big Bear.
Okay. Do you happen to know where that's located?
I don't. I know it's in Michigan, but I'm not sure exactly.
Okay. Do you have, and this might be premature, so it's okay if you don't have an answer, but do you know what any inpatient treatment would do as it relates to parenting time?
I don't. I do know that some treatment centers allow phone calls or video call, but I'm just waiting to see which one he gets into before being able to set that up.
Okay. All right. Thank you. Okay. And at this time, what is the current permanency goal for the child?
It is reunification.
And what are the current barriers to reunification?
The current barriers are some of the same barriers that brought the child into care, which were the domestic violence incidents, now housing and financial instability, and also substance abuse is one of the big ones.
And are there any concerns about Mr. Helton's parenting skills and his ability to appropriately parent the child?
Yes, he has to be redirected multiple times during parenting time visits. And I had even talked to him on December 30th to remind him what the policy rules are for parenting times, which include not talking about the case, not talking about court. And I was told by Mr. Hilton that we can redirect him 100 times and he will continue talking about that.
I believe you included that in your court report. Have there been any parenting classes or parenting programs that you've referred Mr. Helton to yet?
Not yet, no. I'm working on a referral for orchards.
Okay. And would that be for supportive visitation?
No, it would be just working directly with him because we're looking at therapeutic visitation.
Okay. Did Mr. Helton attend the intake for Parkside?
He did not.
Okay. And so therapeutic parenting time is delayed because he failed to attend the intake. Is that a fair summation of where we are with that process?
Yes.
Has he rescheduled that intake with them?
Not yet. I did reach out to them to get more dates because it's difficult to get a hold of Mr. Helton. So I'm just waiting for them to reply.
Is Mr. Helton engaged in any other voluntary services up to this point that would address the barriers to reunification?
He did sign a release so that I was able to make a referral for a psychological evaluation. I'm waiting for that to be scheduled. And he did complete 2 drug screens with me through forensic fluids. One, I have not gotten the results back yet, but the other one is included in my court report, and he did test negative for everything, but was then arrested the next day for having an open container in the car that he was in.
Based on the current barriers to reunification and the current engagement in services, do you believe that there would still be a risk of harm if the child were returned to Mr. Helton's care and custody today?
Yes, I do.
And as it relates to placement for the child, do you believe that he is still in the least restrictive environment to ensure his safety?
Yes.
And do you believe that placement is also following prudent parent protocol by allowing the child to engage in typical life experiences for a child his age?
Yes, I do.
Is there anything you would like to add about the child's well-being at this time?
Just that he is doing very well. I would agree with Mr. Howitt's statement. He is a very, appears to be very, very well adjusted, even though he's gone through a lot of things in his 11 years of life. I was able to find out who his therapist is that's through the school. And she stated the same to me. She just started working with him not too long ago, but she did say that he is a great kid. He's doing well in school, appears to have lots of friends, likes doing sports, especially soccer. And so she's just kind of working on building a rapport with him still at this point.
Is there anything else you'd like to add for the record today?
No, I don't believe so.
Okay. And then just one last piece, Mr. McFarland had brought this up, as relates to the case service plan. It does not have Mr. Helton's signature. Were you able to review that case service plan with him at all?
Yes, and on a couple of different occasions. The most recent one was December 30th, and I attempted to give him another copy because he was still refusing to sign. He stated that he wanted to talk to his lawyer before signing that.
Okay, and is this the piece of paper or court document that the visit notes indicate he tried having the child read?
Yes.
Do you believe that the case service plan as presented today would assist in the goal of reunification?
I do believe so, yes.
And then as it relates to transportation, I know that that might be an issue for Mr. Helton. How has the agency assisted in helping him with transportation for parenting time?
I was able to give him a gas card on Tuesday for his visit, and offered that I will continue giving them to him if that helps him at all. He did ask through the child one day for us to transport him. But I did state to him that that needs to go through us and not the child, so that we can set something up.
Right, thank you. With that, Your Honor, I have no further questions of Ms. De La Garza and ask the court to admit into the record the case service plan and include the case service plan as part of the order today. I'm sorry, Your Honor, that was backwards. Admit into the record the court packet and include the case service plan as part of the order today. Thank you.
Objections?
I have no position.
One question before I can consent, Your Honor.
Okay, Ms. Stang, any objections?
No objections. Thank you.
Mr. McFarland?
Did I hear you say you personally handed the case service plan to my client
Yes, at least 2 times.
and he took it?
Yes.
No objection, Your Honor.
No objections.
Thank you. They are received and will become part of our file. Questions for this witness, Mr. Brooks?
Well, it's clarification I would like to get on something that's already been said. Mr. Howard indicated his last visit with the child was on January the 26th. I'm sure that's not correct. I'd like him to recheck his dates and see when that took place.
I believe I said January 8th, but my visit was January 8th, and I
Thank you.
verified should reflect that.
Thank you.
Ms. Stang, any questions?
No questions. Thank you.
Mr. McFarland?
When I think of arrest in legal terms, I think of somebody detained, transported to the station, booked, fingerprinted. You saying that's what happened to my client? Or did he receive a ticket for open impacts?
I'm not sure, but I do know he has $195 fines that he has to pay because of that.
Well, you said arrest, which is much more serious than a ticket. So are you saying that you don't know whether it's a ticket or an arrest?
I'm not sure. I misspoke. I apologize.
Not a problem. Okay. My client he's expressed to you that he wishes to go to the, I think it's Big Bear up in Midland, Michigan. Is that correct?
Yes.
Would he be transported up there by the agency? How would that happen?
They are one that will come pick him up and transport him.
Okay. And how long has that Big Bend been on the radar as a place for him to go?
He got the recommendations from Catholic Charities on January 8th, I believe, so since then.
Okay. So have you called up there to see what their parenting time options are for my client?
I have not, because I was waiting to see which one he actually was able to get into.
Okay, okay. Client indicates he has a job. Are you aware of that?
I'm not yet, on Tuesday at the visit, he had told his child that he lost the job after 3 days, but I was not aware of this job, no.
Okay. Are you aware that he has located a place for him and the child to stay with somebody?
No, I was not made aware of that.
If he has found someplace, should he provide you the name and contact information of this individual so you can check it out to see if it's appropriate?
Yes,
Would it be correct to presume that the emphasis on the case service plan that my client should focus on right now would be the drug rehab?
yes, that's correct.
Anything else that you can think that he could do in the case service plan while he's in rehab?
Some rehabs, again, I'm not sure because I'm not sure which one he's going to, but some they're able to take some parenting education while they're there. I'm not sure if that's an option or not.
Are there any online classes that he can take?
Yes, through MSU Extension.
So you would let the rehab, whatever he goes to, make them aware of that?
Yes.
See if he has access to the internet to do that?
Yes,
Do you agree that the frequent parenting time with my client and the child is important in the eyes of the child and my client, obviously?
it is what, I'm sorry.
Is important for the child, so the child wants frequent visits.
He wants to continue visiting him, yes, he hasn't stated how frequently.
Okay. I have no further questions.
So has he been referred to housing help? Of one way, or what's going on with housing?
He stated to me that he was going himself to housing help. I did talk to him about the Share the Warmth shelter, but he stated they have too many rules and he did not want to stay there.
And how about employment? You referrals to help him with that?
No, not at this time.
Okay. Have you had an opportunity to talk with him about that?
No, not yet.
How has it been trying to accomplish those conversations with him? Has he been cooperative with that in, using you as a support to look for those referrals, or what's that been like for you?
He is pretty easy to communicate with as long as I'm able to catch him at the office during a parenting time, before, after a parenting time. He does tend to get stuck on that none of this is his fault and his child should not even be in care. And I've tried to redirect him and tell him that he needs to work on things so that he's able to get his child back. But he has been willing to sign releases of information and things like that. I've not had any trouble with that.
Is there a risk of harm for him during parenting time that we should consider restricting it just to therapeutic? By extension, are there therapeutic opportunities? I saw that he's missed like half of the parenting time opportunities. So what are your thoughts on the visitation?
I do believe that they're harmful to the child. That's why we made the referral to therapeutic visitation. Just because he does have to be directed multiple times in the hour visit that they have twice a week. And as you said, he's shown to less than half of the scheduled visits that we have tried to supervise. And during the parenting times, unfortunately, a lot of the discussion that's had is surrounding Mr. Helton's current situation and issues and things that he's going through. Which appears to make the child uncomfortable during those conversations.
I noticed your comments in the court report included that he's also been seen to fall asleep during the visits and also is using a vape in the visit room after being asked not to. Is that common?
The vape, I believe, happened one time, but on Tuesday I did ask him to leave the vape outside of the room that we were in, so that wouldn't be an issue. But the falling asleep, yes, I would say it happens at the majority of the visits, if not all of them.
Is he cooperating with drug testing?
Yes, he has taken a second test, but I don't have the results yet.
What is the status of the therapeutic visitation referral?
So the referral was made and he was supposed to attend the intake so that they could go over goals and things like that on 1/9, but he did not attend. So I'm hoping to get him rescheduled and be able to let him know today in person, since it's difficult to get a hold of him sometimes.
And which provider's doing the therapeutic visitation?
Parkside.
Thank you.
Mhm.
Mr. Howard, I jumped in front of you. Do you have questions?
Just was the child invited to work today?
Yes, he was.
And was he planning to attend?
He was planning on attending, yes.
But did you hear anything since you met with him that he may have changed his mind?
Yes, I did hear this morning that because they had no school last night, he wanted to spend the night at his friend's house, which would mean he wouldn't be able to attend court. And he stated that he was fine with that because he would rather be at his friend's.
Nothing further.
Any redirect, Ms. Thomas?
No, Your Honor, thank you.
Any recross from our attorneys?
No,
One
No,
question. Are you aware that my client missed parenting time because he had an operation to remove a pinky toe from frostbite? Were you made aware of that?
No, he told me that that surgery occurred on the 9th, which is why he missed the intake appointment, not his parenting time.
Okay, nothing further.
Nothing further.
Thank you for your testimony. We are adjourned. Any other witnesses, Ms. Thomas?
No, Your Honor, thank you.
Any witness testimony today, Ms. Stang?
no, thank you.
Mr. McCrum?
My client wishes to testify.
Mr. Houghton, come on up for a witness stand.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
So we got.
Watch your step.
Wow, shit. Oh,
We call you Mr. Helton or John or something else?
John's fine.
John, is it true that you wish to go to a drug inpatient treatment program?
Yes, I'm scheduled to go to Big Bear as soon as the bed opens up.
Okay. And you've been in contact with somebody from up there, have you?
No, not up there, through Catholic Charities. My worker at Catholic Charities has been in contact with me twice, it's probably the day or tomorrow.
Okay. Are you currently employed with Lightning Quick?
Yes,
Okay. That's a gas station party store setup, is it?
it's a gas station price store. Oh, there was an incident where somebody said I stole something. They looked at the tape. I didn't see anything, so I thought I lost my job, but I didn't.
And which Lightning Quick is this?
It's the one over by the prison.
Okay, on Beecher, they
Yep.
don't sell gas, just inside, right?
Right.
Okay. How many hours a week are you working there?
10, scheduled 10 hours while I'm getting trained, and then after I'm trained, I'll move on to part-time for now.
You heard the worker say you don't want to stay at Share the Wealth because you don't want to follow rules. What's your position on your housing situation? Have you found a place to live?
I have found a place to live, but only if I get Zane back.
Okay, and this individual, does she have other children in the house?
She has 4.
Okay, and she's willing to take you and your son in the house?
She's a bus driver for the community. Yes.
Would you be willing to share her information with the worker so they can inspect her in the house to make sure that it's appropriate?
Absolutely.
Okay. I know you told me you didn't sign this case service plan because you weren't served with it that you remember, correct?
Right.
You did have a chance to read it today, correct?
Correct.
Are you in agreement with it?
All except for H.
No, let me go back to H here. You agreed to participate in recommended parenting education services and will show benefit from the services. Is that what you disagree with?
No, that's not the one.
Can I present the copy? I'll let you take a quick look and read us a section of what you disagree with and then tell us why. Give you a chance to read it first.
I'm sorry, it was G. It's, Mr. Helton II agrees to attend and participate at substance abuse, thus, whatever humans, and follow all recommendations from that evaluation. That's not it either. It's the one where it says that a denied drug test or a refusal of a drug test will automatically be
Considered a positive test,
it's a
right?
positive test. Yeah. It's just that. That's the only one.
Why do you disagree with you refusing? Do you understand the reason it's there is because they think you don't take a test because you have something to hide? Do you understand that?
Yeah, I understand, but I've taken 2 tests and they're negative. They're gonna keep coming back negative because I don't do that substance anymore. I do that because anything could happen, like me not get this, then told that I was, because I didn't get that. I was told that she had it for me, but I never seen it. We never went over it till today.
Well, right now, it'd be correct to say you're homeless, right?
Yes.
How is the best way for us to get stuff to you? Do you have access to email or?
I do have an email. It's jhelton@gmail.com or 1993@gmail.com. JAYHELTON1993@gmail.com.
And you have a phone and you have a way to charge your phone and a way to have internet access to you?
I just got my phone turned on again. However, it's been through some tough times here in the past month and a half in the woods, getting wet, cold, stuff like that. Smelling a campfire.
You understand that the issue they're having with your parenting time is that you're discussing aspects about this case, aspects about your personal life, which may trouble your son.
Well, that's secondary also. I always ask him how he is about himself first.
But they don't want the secondary part is what I'm saying. Do you understand that?
Well, if you give somebody communication, it's the most important person in your life, right? And then you guys come along and make these decisions where you take that person out of his life, except for an hour a week. Well, there's nothing you can do in this world to keep from talking to my son about the most important thing that's going on in our life right now, which is this case. Sorry.
Any other aspects of this case that you wish to address today?
Yeah, I'd like to say that the first time I seen a CPS worker, I told her to get out of my yard, and then I slipped up and started talking to her and let her gain my confidence and let her talk to my son and gave her a drug test, which was the first time I seen her for. I was making and distributing methamphetamines, and they searched my premises, didn't find nothing. Then the second one was because my son got out of the shower and had his computer on.
Well, I'm talking about the last time from our last time in court till now. That's what I'm asking. Well, let me rephrase that.
I know she gave me a $10 cash card. It's the first help that I've gotten from anyone since this case began.
So do you need help with food?
Yes.
Okay. Sounds like you need help with transportation,
Yes.
correct? Do you have a bike or anything like that?
Yeah, I have like.
Do you have a tent or anything? Could you use that?
Yeah, I could use a tent, actually, because I'm using tarps right now. But I have a place.
Do you have a sleeping bag?
No, I don't have sleeping bag.
Could you use these essentials to live until you get into drug rehab?
Yeah, I could, but I'm pretty sure I'm leaving today or tomorrow. I'm trying to clean this up as fast as I can and put Adrian 10,000 miles behind us.
Thank you. I'll see if anybody else has questions for you.
Does Thomas, any questions?
Just a couple. Mr. Helton, at the last hearing, you reported that you were living with a friend. What happened to that housing?
It was the holidays and he has a family of his own and they was having problems and I didn't want to weigh on them. So I took myself out of the picture.
And I maybe misread some of the notes from the visitation, but it seems like you did have, was it you that had a food stamp card to go, that you plan on going to Dollar General, or was that your child who said that they were going to Dollar General to buy food?
I don't remember having a conversation at all.
Okay, so do you have a food card?
No.
Okay.
Can you speak up just a
Have you-
bit for me?
No,
Thank you.
Have you attempted to go to the department and apply for financial assistance related to food? Or even like the state emergency
have.
relief fund?
I have food stamp card. Rick's got it and he uses it for my son. I'm not gonna take my son's food.
Okay, okay. And then as relates to share the warmth, the report indicates you did not want to go there because it had too many rules. Is that accurate?
It is.
Okay. What are the rules that you don't agree with there?
Well, during the intake, I informed, the guy that I didn't want to stay there for that night. The night that I signed in, and he told me, that's fine, just come in and get, get the intake done, and then, I could leave. Well, I got the intake done, and I'm gonna leave, and he said if I left, that I couldn't come back for 3 days. And I said, what do you mean? You just got through telling me, I just got through telling you that I wasn't gonna stay here for the night. We was just gonna take care of the intake. It's like, anyway, I don't know what he was thinking or why he thought that. But he kicked me out for 3 days after I made him agree to before I did the intake that I could leave. So I don't like to be around people like that. You just never know when you're gonna get in trouble when people ain't got their information correct.
And what was the reason you did not attend the intake with Parkside for the therapeutic parenting time?
I was in surgery.
Okay, okay,
Well, no, excuse me, I didn't have surgery that day. I was there to get my little toe looked at again to see if I had to go to surgery.
all right, thank you. I have no further questions.
Any questions, Mr. Brooks?
No, Your Honor.
Ms. Stang?
Yes, just briefly, thank you. Mr. Houghton, you testified earlier that you had found a place to live, but only if you get the minor child. Why is there a stipulation on you having to have the minor child to live there?
Well, because she's a upstanding person in the community, and she believes that she don't want people to see it as we're having a relationship. She wants to see it as it's my son's best friend, JB, his mother, Rachel, who's got 4 kids, been doing it by herself for a long time, outstanding person, and outstanding community leader, actually. Her and my pastor, D'Angelo, came up with the idea that, I could stay there, but I have to have my son, and then I can stay there. If I don't have my son, I can't stay there.
Will you be required to pay any sort of rent or living costs if you stay there?
No, but I would anyway.
Okay, I have nothing further. Thank you.
Mr. Howard, any questions?
Yes. How are they in contact with you about the availability of the drug rehab facility?
I go there every day and check in.
Just the Catholic Charities?
Yeah.
Nothing further.
Mr. McFarland, any redirect?
Well, thank you.
Okay, thank you for your testimony. You may return your seat. Anyone else who'd like to hear from Mr. McFarland?
I'd like to hear from the worker. I have a couple questions.
All right, Ms. De La Garza, you could just stay where you are unless you think it'll be extended.
No. You've heard my clients, it sounds like a request for a home study on this individual. Is that something that you'll be conducting as a home study on this individual?
Yes, we can do that.
Okay. You heard he needs some essentials, a tent, sleeping bag, things like that. Can your agency help provide some of these essentials for him?
I can look into that for sure, yes.
I have no further questions.
Anyone else have any follow-up questions for Ms. De La Garza?
No.
No, Your Honor.
Thank you for your testimony. Mr. McFarland, anyone else?
No, thank you.
Mr. Howard?
No, Your Honor.
All right, I look forward to comments closing, beginning with Ms. Thomas.
Thank you, Honor. At this time, we are still obviously recommending reunification with dad. And I think that parenting time, it sounds by what we have in the record so far is best suited through therapeutic parenting time. It's wonderful that the youth is resilient and that he's had to be. It's unfortunate that he's had to be, though. I think that the family dynamic really could use some repair, and I think the therapeutic approach would be most appropriate at this time, especially with some of the concerns that are brought up about the content of their visits. I think that the oversight would be most beneficial. However, I do understand and hear the LJL's concerns that if we're limited in time to just therapeutic, that would be detrimental for the child as well. So I just asked the court to issue an order with clarity to ensure that the agency knows exactly what's expected regarding parenting time. I think that the case service plan is appropriate to enter into at this time as well. I think it sufficiently addresses the barriers and the reasons that the conditions that led to adjudication and removal. I wish Mr. Houghton the best in his recovery. If he, I hope that he does choose to go to inpatient treatment and really commit to recovery and that process. Otherwise, Your Honor, we would just ask for that standard 90-day review. Thank you.
Okay, any comments today, Ms. Stang?
Yes, thank you. Based on the testimony that was given regarding the visits, the supervised visits, we would request remain in place in addition to the therapeutic visits that it sounds like are being worked on. I do know that it is the minor child's wishes to be able to see his dad as often as he can. He also wishes for the visits to not have to be so clinical per se in terms of scheduled dates and times, supervision, all of that. But we understand, obviously, that that's required at this point. So we would just request that he be able to continue to have those therapeutic visits in addition with the supervised visits that are already occurring. In the event that the visits would become inappropriate, if they did remain supervised, those obviously would be terminated if and when the inappropriate conversation was initiated by Mr. Houghton or when he fell asleep. Because there's no therapeutic visits scheduled at this point in time, that is the concern that, it may take some time, and the minor child does wish to be able to maintain that contact with his father and see him as often as he can. So that would be our request, and then we agree with the standard 90-day review. Thank you.
Mr. Brooks, any further comments?
No, Your Honor.
Mr. McFarland?
Well, my client is in agreement that the most important aspect right now is his drug rehab. He's going to Catholic Charities despite no transportation, being homeless every single day. Check to see when bed's available. I think it's Big Bear up in Midland, Michigan. So he wishes to do that. He's testified to this court that he's not using drugs right now. That the allegations are, findings are he's a functional addict, but he's not using right now, which can't be. Down and out, you'd think he'd be using, and if any time he used, it'd be now, and he's refraining from it. Says a lot. A little compassion for him falling asleep during visits. He has no shelter. Not a lot of sleep, staying warm by a fire at night. So I don't see that being an issue. He has heard what he's not supposed to discuss and why. So that's come out today. I can see when there's a bad pill in his mouth when he asked if he could come in and get warm and at least take a look at the process for joining the shelter. And then when he didn't wish to fill out the application form, they said you couldn't return in 3 days, that he was misdirected. And that is bitter for a homeless person to be treated like that, providing that. And we've heard no testimony that that was not the case. He could use some essentials. We'd ask the agency to help him with some necessities so he doesn't lose another toe. I know my client does not wish to have the therapeutic visits, Your Honor. I think that covers it right now. Thank you. Oh, and we do want the individual checked out. He can provide all that information for placement for the child. Thank you.
Thank you. Mr. Howard?
Yes, Your Honor, I know it's very important for the child to see his dad, especially right now. I do think he does worry about him and his well-being, but at the same time, I do believe therapeutic visits are what's best for him. And, you know, in a perfect world, they would occur once or twice a week to allow for that relationship to heal and then, you know, grow in a positive way. I do worry about the inpatient rehab and the availability to conduct them virtually, but I know in past cases, we've had some success with this provider offering virtual therapeutic visitation. So I just ask that that option is explored if Mr. Houghton is able to get up to Midland in the next couple of days. Thank you.
Thank you. The court finds all interested parties were given notice for purposes of today's initial disposition. It will also issue a pretrial order as it relates to the mother documenting that we looked at her case and we've set a trial date. I received the motion for alternative service. I've reviewed that and indicated that I'm granting the motion for alternative service and requesting that the department perform publication in the last known county for Ms. Nicole Riley and down in Texas, as well as to notify her through any social media accounts that are found and appear to be associated with her as relates to the adjudication trial and potentially the initial disposition that's been set for March 24th at 11 a.m. She remains absent, unreachable, and is clearly not an available placement for her child, nor has she been for the majority of his life. As it relates to Mr. Helton, the challenges identified at adjudication remain consistent with the testimony that I've heard today. The child's placement with his uncle, which is where he was living before the court formally removed him from his father's authority, will remain in full force and effect. That is the safest and least restrictive for him under the circumstances. Mr. Helton's removal from the property where the child was residing in the trailer in the backyard appears to still be the case. And as he looks for housing, consistent employment, income, the safety and stability of sobriety, stabilization of mental health needs, the child will remain under the authority of and in the household of his uncle. We would look for Mr. Helton to participate in therapeutic parenting time in addition to the supervised parenting time. That may be consolidated to a once a week visit for 2 hours or however that can be accomplished, especially in light of the fact that he's missed half of the visits with this child up to this point. I appreciate that he's been able to make it to Catholic Charities and maybe to secure employment, but the frequency of his contacts with this child is clearly important, and it's as important to him to maintain that relationship with his child as he says it is, and I would expect him to appear at the parenting time and to participate in the therapeutic parenting time. As I do with all parents, I'm instructing Mr. Helton specifically not to discuss the case with the child, not to make the child feel guilty about removal, or to ask the child to take on any of the adult responsibilities that Mr. Helton is responsible for, like housing, employment, sobriety, parenting education, or many of the other things that are a part of his case services plan. If he's not able to do that, the agency and the therapeutic parenting time supervisor are both asked to terminate those visits because they are a risk of harm to the mental health of the child and to the bond between the parent and the child. I'm not interested in making things more complicated for Mr. Helton or his son, or in Mr. Helton doing that either. So those will be the parameters for purposes of visitation. Ask Ms. De La Garza to offer maybe a meeting about what parenting time could look like. If it needs to be modified to once a week, if that's easier for him to get to. But those parameters around parenting time and the parenting time rules established for all parents by the agency and therapeutic parenting time providers are to be respected. Mr. Helton can't be an exception to those rules either. So that will be the order of the court moving forward. We have our next review and permanency planning hearing scheduled already for March 24th at 11 a.m. I'll be providing a copy of this order in just a few minutes to your client, Mr. McFarland, and I would encourage you again to discuss the appeal issues with him that were identified on record and make sure he understands those. The case services plan will be accepted and will become part of the court order moving forward. Mr. McFarland, I'm sure you can also address with your client that if there's indications of sobriety in other areas, that the court doesn't always just consider a positive or a missed screen as a positive screen. That those drug screens are important, especially in this case.
Sure.
So I will not be altering the case services plan, but I will reassure you that I do take that into consideration. That it's not always necessarily a positive drug screen, but also other indications of sobriety are considered. Anything else for the record from our attorneys for today?
No, Your Honor.
No,
All right, thank you.